possible that I could provide evidence that this guy is guilty. She essentially said that. She's never seen any of the evidence. She's never, not a bit of it. But that's what she's claiming. And that's why she did it with prejudice, is because, well, I won't go into it, but that's the game she's playing, Remy. She's taking this to a preposterous extreme because she's deliberately doing it. She's trying to find a way to get out of this lawsuit. She doesn't want to deal with me. She doesn't want to let me win. She doesn't want me, she's not going to allow me to litigate my case.
It's strongly essentially tightened up the standards a little bit. And what they said was this. First of all, that there has to be a factual basis for the complaint. So that the plaintiff has to lay out a scenario of facts. And it's not enough simply to lay out conclusions. So you can't say something like, I think the defendant violated my rights. That's your... Yes,
you can, actually. There's been plenty. I bet you, if we go research, we'll find circumstances where somebody said something almost that simple. Okay? That the guy broke into my house and violated my rights. Something that simple. Some simple description of an event, a law being broken.
Conclusion, but you haven't laid out the factual basis. So there's got to be that factual basis, and without a factual basis, then the claim is dismissed.
And the factual basis is also established by the DMCA process itself, okay? So there's already built into that, the complaint is almost initiated by the event of the processing of that form. Your ownership is being established, that you own the video. You're making the claim on the video you possess that you own, and you're telling somebody else they can't use it, and it's the whole, it's right in the process itself. I mean, the law provides the complaint for a DMCA-initiated lawsuit is on its face legitimate.
It says that the facts that are laid out need to lead plausibly to the conclusion that the defendant's rights have been, the plaintiff's rights have been violated. It's not enough for the conclusion to be something possible. Yeah, it's
yeah, so let's talk about the words possible and plausible. I mean, really, again, they're not that distinct. They're not miles and miles away from each other. Plausible is basically just possible, with just a tiny, tiny bit more credibility.
A little hard to sort of wrap your head around this distinction between plausible and possible at first, because I think the courts are using these terms in ways that are a bit different from the way we use them in colloquial, everyday language.
Well, what we know they're not goddamn doing, and what the case law will demonstrate, I'm sure, in the future, is they're certainly not turning the word plausible to mean probable, which you just fucking did. There's no need to prove probability. And if you look at the two cases, these cases were found to be implausible, because of the fact that the accusations were so fucking thin. So read the goddamn cases where these words were applied. This word was applied to people who were claiming that the owners of some train company had, through a conspiracy, conspired to destroy their insurance coverage and all this other stuff, and they had nothing. All they had was an end product where they lost their coverage, but they had absolutely they explained no scenario besides secret meetings that they had no evidence of to explain what the fuck happened. And so there was nothing there. And so the court, decided that, we're not going to investigate and go through all this crap based on such a thin piece of evidence. You have to bring us a little bit more than that to make this reality fit, where we can say it's plausible that this took place, because the claim is just so unsubstantiated. You can make it about anybody on planet Earth. That's almost the argument. It's like, I could say it about anybody. I call anybody a Martian. I have to have some reason to call this particular individual a Martian.
But I think I've sort of got it down. Let me explain my understanding of the distinction between plausible and possible. Let's take a set of facts A, and you're trying to reach a conclusion X on the basis of those facts. You've got a plausible case if, when you take into consideration these facts A, you're led kind of inexorably to conclusion X.
That's crazy. That's just that's a probable definition. That's a definition of probable, Remy. Okay? I mean, if A leads to, let's say, W. W is the end result. That W is the correct answer. And you're saying that the case from the complaint has to lead to W, conviction. I mean, that's just nonsense. That it's probable that they're guilty. I mean, it's just nonsense. Like I said, that takes substantial evidence to make that case. I mean, to make a probable case, that's probable is just a tiny bit beyond a reasonable doubt. I mean, probable is just below reasonable doubt, and plausible is just a little above possible. You're getting these fucking terms completely upside down, and you're fucking me with it, you dumbass.
Conclusion that can be drawn, or at least it's the most probable conclusion that can be drawn. Then you've got a plausible.
That's a complete perversion of why the court used the word. They only used the word to sit there and narrow the word possible, any set of facts, to narrow the word any set of facts to something like a set of reasonable facts, a set of facts that fit into some smaller, more rational container, not a set of facts that you can just make up any kind of scenario, like the sun really isn't the center of the solar system. It's possible it's not. It's possible it's an optical illusion all this time. We completely fucked it up. But that's not very likely. It's not very plausible, is it? No, it's not plausible. So it's more about the word, like I said, what's going to come down in the end, it's more about the word implausibility than it's the word plausible. Use the word implausible and you'll understand this.
A complaint is possible if, given these facts A, you could conclude X, also conclude Y or Z. X is one of simply a number of conclusions that can be drawn on the basis of this set of facts. In that case, the argument is possible.
No. So again, plausible just means that, yeah, plausible is possible with a little extra. Plausible means that, yes, you can make a plausible case for it ending up at C. You can make a plausible case for it ending up at D. You can end up a plausible case for every letter in the alphabet. Okay? They're all plausible. More than one choice can be plausible. Moron.
Rather than plausible. And according to the Quambley-Iqbal standards, this is not good enough. A plausible case has to be established. So given that, let me...
Yeah, well, given that. So given your false premise that plausible means probable, which it doesn't, yes, now you're going to say some more crap.
Let me read from your complaint, and just bring it up right here. This is the section of your complaint filed 2 of 708, in which you try to lay out your cause of action. It's 2 paragraphs. The first paragraph is pretty much just...
Again, as Section 8 says, a short, plain statement. That's what I provided the court. A short, plain statement outlining what law had been violated, who and who violated it.
It just states what your claims are, essentially. And those come in the form of conclusions that you draw.
No, it's allegations is what they're called. See, again, Remy, you just want to keep perverting everything. So you have to pervert the word conclusions I draw. No, they're clearly allegations. They're allegations of a crime, of an event that I allege took place.
The second paragraph is really the substance of it. It's 4 sentences long, so let me just read that.
Yeah, and it's 4 sentences long because I know how to write a concise, plain, simple, direct statement outlining a crime. And that's what I fucking did. And I bet you can't find one fucking lawyer in the United States willing to take a polygraph test and say when they read that complaint they don't know what law was violated or how it was violated. I bet you can't find one fucking person that could take a polygraph test and fail, and say they didn't understand it and not have failed the test. Where's your part 2? There it is, right in front of me. Sorry, this is a long video.
Both plaintiff and defendants have active accounts with YouTube.com, the most popular internet video display service. Defendants have produced numerous videos that use in various manifestations the video content produced by the plaintiff.
Right. Very clear, alleged facts. Very clear. I mean, just points out exactly how these individuals had means to commit the crime I'm alleging.
Plaintiff believes the use constitutes malicious libel and defamation and falls outside...
Right, and that's the alleged violation of law, and that's what I will intend to prove. That's the claim.
Any fair use exception to federal copyright protections. This action was initiated through filing of DMC complaints in accordance with the YouTube terms of service and enforcement policies. And then it follows that with a list of some email accounts of the principal people involved in this case. Yeah,
and you changed it to, right, their YouTube accounts. Right, where if the court or somebody was so disposed to go find some shit, they could go find a video of me, my video, where somebody had vomit coming out of my mouth and me going, blah, 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 blah. Right. Yeah, I thought that, just to add a little weight to the goddamn complaint, I just throw in, if you want to go look at some of this shit, here's some of the channels with some of this shit on it.
Most of which are no longer open to see. So anyway, that is your cause of action. As I said, it's 4 sentences long. One sentence is purely conclusory. Right, and that's the one where it says plaintiff believes the use constitutes malicious libel and defamation.
I mean, plaintiff believes, and then to describe what I believe, that's an allegation. You know, when they were confining the complaint against O.J. Simpson, I'm sure they said, we believe O.J. Simpson, blah, 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 wife head off. Okay? I'm sure they put we believes. The prosecutors use the word we believe lots in their fucking accusations. And then they go and they prove what they fucking believe. Because they believe they can fucking prove it. Which I said in the first sentence or whatever.
Falls outside any fair use exception. So that was a conclusion you were drawing. The other 3 sentences could be said to be factual in some way or the other. But 2 of those factual statements really do not support any kind of complaint. They provide a kind of context.
Oh, bullshit. They're clearly allegations.
From the one where you say both plaintiffs and defendants have active accounts with YouTube, that doesn't lead to any plausible conclusion of wrongdoing.
Plausible. Again, it doesn't. Again, you're misinterpreting the word. It is not probable. It's just plausible. That means, of course, them having an account establishes a means. There's no means of the crime. You certainly have to articulate why there's a means, a possibility that the crime took place, and that's what it does. It establishes plausibility. You have to have a YouTube account to basically violate the fucking to commit the crime. You have to have the fucking account.
The action was initiated for filing of DMC complaints in accordance with YouTube terms of service. Again, that tells how the case came about, but it doesn't support in and of itself any kind of conclusion.
Yeah, well, it supports the idea that there was a process you go through in accordance with the goddamn law, and I followed the goddamn process. And so I'm making a copyright violation claim. That's what it stemmed from, is that this is the way the law is prosecuted.
Well, wrong. And again, of course, DMC false DMC complaints follow all the time. So,
Name one. Remy, name one of them that got to a courtroom door. Name one of them that resulted in a complaint being filed. Name one false DMCA that resulted in a complaint being fucking filed. So obviously false DMCAs don't end up in fucking court, do they, fucking Remy? So that's fucking irrelevant, isn't it, fucking Remy? But again, your fucking distortion of the fucking reality because you're a petty fucking weasel that is just deliberately trying to engineer some way to say Mendham's wrong and this dirty, stinking, corrupt motherfucking system is somehow doing something right. You're such a fucking cunt. The smelliest and skankiest of them fucking all because you are pretending to be something else. Fuck you.
Just the last of those factual sentences. This is the only one that may be said to support a claim in some ways. Let me read it again. Defendants have produced numerous videos that use in various manifestations the video content produced by the plaintiff. And that's it. First of all, note that says absolutely nothing about your Bible claims. So,
yeah, well, that's in the other